Members of the jury moved to found the defendant, Aileen Wuornos, guilty of murder in first degree. Punishment for this crime is either death or life in prison without possibility of parole for 25 years. Final decision as to what punishment shall be imposed rests solely with the judge of this court. However, the law requires that you, the jury, render to the court an advisory sentence as to what punishment should be imposed upon the defendant. The state and the defendant may now present evidence relative to the nature of the crime and the character of the defendant. You are instructed that this evidence, when you consider with the evidence that you have already heard, is presented in order that you may determine, first, whether sufficient aggravating circumstances exist that would justify the imposition of the death penalty, and second, whether these mitigating circumstances are sufficient to outweigh the aggravating circumstances, if any. At the conclusion of the taking of the evidence and after argument of counsel, you will be instructed on the factors of aggravation and mitigation that you may consider. Counsel, if you desire to make opening statements, you desire to present testimony.
Your Honor, we have a moment to make
yes,
brief opening statements.
Yes, sir. I don't need this. That's it.
Can I proceed, Your Honor?
Yes, sir.
Well, we're not at the end of the case, but let me just give you a brief idea of what to expect. I have an opportunity to make an opening statement at this time, as does defense counsel. And His Honor will, after you hear evidence, then give you some more instructions. The penalty phase in Florida is separated from the guilt or innocence phase, and it's usually separated just by the very nature, by a little bit of time. There's a reason for that. And I think it's primarily to give juries an opportunity to settle down and, without passion or prejudice or bias or sympathy or anger, then make a very calm, deliberate, and just decision with regard to punishment without being so close to time that the guilt or the innocence phase is being decided. Even though your verdict as to penalty is advisory, it carries great weight in Florida. It is very seriously considered by the court. And the law in the state of Florida is such that certainly, and I know you wouldn't, but certainly you should not think, well, it's really up to the judge, it's not too important. It's very, very important. It's what you do or do not recommend. But the final decision and, of course, responsibility is up to the presiding judge in the trial. And, of course, this case, we know it's Honorable Uriel Jr. The verdict need not be unanimous. You recall the verdicts that you returned last night by law are necessarily unanimous. But as to the penalty phase, the verdict need not be unanimous. But a majority must vote to recommend the death sentence, if in fact that is to be the recommendation. In other words, it would take a minimum of 7 jurors to vote in favor of or supportive of the death penalty before that would be the recommendation. If it was a 6-6 split, then the recommendation is for life imprisonment. The aggravating and mitigating factors have been established by statute, so you're not going to be left to try to figure out what is or isn't be considered in the first place. Will not be presenting anything that's not lawful. Judge Blunt will see to that if we're not able to do that on our own training. He's here to make sure you only receive lawful evidence. And your decision really will be to decide whether or not the aggravating factors would justify the imposition of the death sentence, or whether there are such mitigating factors presented, if they are presented, which would outweigh the aggravating factors and therefore justify life.
Objection, Your Honor.
The burden with regard to proof is still on the state. It must be beyond a reasonable doubt. And the defense I believe at this point still has virtually no burden. We have a burden. Most of the aggravating factors that we would present have already been proven in the trial. And to tell you that, to let you understand two things. One, yes, you not only may, but you should consider the evidence you've heard up to this point. That's part of the state's evidence with regard to the aggravating factors. In fact, it is the majority of that evidence. You will hear some additional evidence, but we will not go back and present the whole case again at all. One, that's not permissible, and number two, certainly it's not necessary. You've already heard it. So what you've heard in trial to this day should be considered as you determine the aggravating factors. The aggravating factors that the state intends to prove, which we believe will justify and do justify a recommendation that Ms. Wuornos receive the sentence of death, are as follows. One, that she has previously been convicted of another felony, separate from the ones here, involving the use of violence or the threat of violence against another person. Number two, that this particular conviction of murder in the first degree, which your verdict confirmed and in fact was the final arbiter last night, that it was committed while in the act of carrying out a robbery. And of course your verdict confirms that already. You've already made that decision.
Objection, Your Honor.
And next, that the murder was committed to avoid or prevent, in effect, Ms. Wuornos' arrest. And that was already presented to you, Deputy Gorzeva's testimony, and almost 2 weeks ago now, with regard to witness elimination. And she, on the witness stand herself, told you that she felt no one would believe her who took her story in this investing context, and therefore she decided to kill him so he couldn't tell on it. That is, in fact, killing someone to avoid being arrested and held responsible for your acts. Next, that the felony robbery, the murder, was carried out for the purpose of obtaining financial gain. There's been overwhelming evidence of that, the selling of the property and the keeping of the property. And finally, that the murder was committed in a cold and calculated and premeditated manner without any pretense of moral or legal justification. Again, I would respectfully say that your verdict has confirmed that it was a premeditated murder, and that her, certainly from the time she fired the initial shots, if the premeditation was not firmly established before she did, we contend that it was. That's why she had a pistol. But in any event, certainly as the succeeding shots were delivered and ultimately as she went around and confronted Mr. Mallory and shot him virtually to death, that amply supports the aggravating factor of cold, calculated, and premeditated.
With all due respect, Mr. Tanner, objection, Your Honor, heightened premeditation.
Don't be led astray as you listen to the evidence. We need not prove every possible aggravating factor recognizable under the law. There are many recognizable under the law, such as that the murderer was under another sentence at the time they committed the crime, or it was meant to disrupt government, or that a government official was killed in the performance of his duties, or a police officer in the performance of his duties. Or even the particular aspect of requiring particularly heinous, cruel, or atrocious torture-type murder. The state doesn't have to prove that to justify and to seek and to obtain a recommendation of the death sentence. Those are just some other aggravating factors that appear in some cases. They don't appear in this case. And we're not asking you to consider those as aggravating factors. You will hear perhaps other evidence of mitigating factors. Don't believe that this is simply a balancing test as to how many versus how many. You may give such weight as you see to each aggravating factor, or such weight as you see, or lack of weight, to each mitigating factor. And if even one aggravating factor would, in your opinion, majority of you justify the imposition of the death sentence, and that is sufficient. We believe that the evidence that we will present over the next day and a half will convince you that the sentence that is appropriate in this case, the sentence that would do justice, and the sentence which is justified by the evidence, is a sentence that Aileen Wuornos stay with her life for the crime she committed in murder against another. Thank you.
So, you never make no attempt to deserve what was said.
Your Honor, I would prefer to make it at this time.
Sir.
Mr. Tanner, Mr. Miller, Ms. Jenkins, Your Honor, ladies and gentlemen of the jury, good afternoon. You've heard 2 weeks of state's evidence regarding Ms. Wuornos' guilt. You've seen Lee Wuornos testify from the stand. You saw her cross-examination. You observed her demeanor. You've seen her here in court. And some of you must have observed her behavior here in court during the course of the last 2 weeks. And I dare say that many of you must have been thinking to yourselves, why? Why is this? Why is Lee the way she is? This is the part of the case where you get answers to the question of why. Mr. Tanner talked to you a little bit about aggravating and mitigating factors. His Honor will instruct you at the end of the case that any aspect, anything regarding the accused, which you as a juror believe to be a mitigating factor, is sufficient to warrant a vote that Lee Wuornos not be sent to her death, but that she be sentenced to life imprisonment. Mitigating factors, as His Honor will instruct you, are not limited. And they are reasons why you as a juror can say, for this reason, I will vote to spare her life. People do not simply fall from the sky. Lee Wuornos did not simply fall from the sky. Her biological father, the evidence which you will hear will indicate to you, was a person who hanged himself in a penitentiary where he had been convicted of kidnapping. Her biological mother abandoned her before she saw her first birthday. Lee Wuornos did not simply fall from the sky. There are biological, genetic, and environmental factors that make each and every one of us what we are. And there are such factors here. And they make Lee Wuornos what she is. And when you hear those factors, those mitigating factors, factors that our law has as the embodiment of the compassion, the mercy, and the justice that we as a people hold dear, we are going to stand before you and ask you not to impose a sentence of death on this woman. Lee Wuornos, you will hear from the evidence that will be presented from the time she was a little kid, 6, 7, 8 years old. Her school records consistently reflected, this is a person who is impaired. This is a person who is not well. This is a person who needs help. She never got that help. She was raised by her grandfather, a person who you will hear evidence on, drank. He was an alcoholic. He was a drunkard. And we will hear evidence about his being abusive. Lee's grandmother, a person who Lee believed to be her mother up until her teenage years, is a person who Lee described as a heavenly angel. She feels for her. She loves her. She's not deceased. She loved her. And this heavenly angel was a person who was meek and humble, and the person who could not intervene when Lee needed help. A person who could not deal with the dysfunctional family in which Lee was raised. You will hear evidence during the course of this proceeding answering that question, why, about a fire in which Lee was burned when she was a young child, and about the problems with her self-image resulting from that fire. During this proceeding, you will learn about the fact that Lee was raped when she was 14 years old. And I know that's a word that's been used during the last 2 weeks. She was sexually abused and raped by a gentleman in his 40s. And she became pregnant. And she was so terrified of what her family would think of her that she tried to hide the pregnancy. And eventually nature took its course and the pregnancy could not be hidden. And the grandfather found out, and he was ashamed. And he sent her to an unwed mother's home. And there she had the child she never knew, the child that was taken away from her. People don't fall from the sky. Lee Wuornos did not fall from the sky. There are things that she was born with, and things that affected her as she grew up, and things that mitigated in this case. At the age of 15, Lee was put out of her home. She had no skills. You will hear about her school records. You will hear about the fact that she had no skills. She hitchhiked from place to place, and she did, in order to make a living, the one thing that apparently she could do. She sold her body. You will hear about the fact that she was abused physically and sexually on a number of occasions while hitchhiking, while trying to make a living by selling her body. You will hear that she became an alcoholic. And you will hear that as she grew older, things got worse. You will hear about a young man that Lee loved very much, who left her. And because she left her, Lee got herself a gun and shot herself in the stomach, trying to kill herself. And you will hear evidence about Lee's impairments, about what the genetic and the biological factors, and about what this environment has done to Lee. You will hear about why she is sitting before you today with this demeanor when you will be deciding whether she lives or dies. You will hear that for Lee, the world is a very strange place. It is a hostile, it is a frightening, it is a bitter place. She doesn't see the world the way you and I see it. She doesn't understand the world the way you and I understand it. She cannot function in it the way you and I function in it. You will hear about her cortical impairments, about her inability to control her impulses, her inability to reason, her disturbances, her impairments, her inability to cope with the world around her. It is to her a hostile, frightening place. And the way she reacts, because it is a hostile, frightening place, is a way that we see as inappropriate. This honor will instruct you on mitigating factors. You as jurors, when you consider mitigating factors, you have a very hard job. You have to look at the world, only for a moment, through the eyes of somebody who is impaired, who is not like you and I. And you have to see the world through those eyes. You have to see the frightening, persecutory world in which Lee Wuornos has lived and now lives. A world in which she has no solace. A world in which she has no place. And yet a world which has made her what she is, and which counsels you as a jury to say, yes, I understand mitigating factors. I understand what they are. I understand there are reasons why I should spare a life. And when someone is this impaired, when someone's deficits are so great, I will say life in prison. I will not vote to take that life.